All right, we're good.
All right. Well, good morning, everyone, and welcome to the December 14th, 2022 Mine Land Reclamation meeting. This obviously is a virtual meeting. So if you have any problems, Cammie, everyone has your contact for the audience to get a hold of you if they have problems during the session.
I'm assuming so. I hope so.
Okay. If not, it is on the meeting agenda. Her email, just ping her a note in the audience if you lose connection at any time. All right, let's start off with roll call of the board. Tim Mock.
Present.
Patrick Ortiz.
Present.
John Singletary.
Here.
And Nell Orem Morris is absent today, so we just have a quorum. Thank you for making time and your attendance today. First item is to go over and approve the minutes of the November 2022 meeting. Everybody got those in their packet. Any comments, questions?
Motion to approve the 2022 November summary of minutes.
Second.
All right, all in favor, say aye.
Aye.
Opposed, same sign. All right, that one's easy. Let's move on to the approval of continuances and withdrawals. We again have the continuance of two continuances here for Grand Island Resources. Any comments, questions?
I move to approve the continuances and withdrawals. I don't
Okay,
think we have any withdrawals, but continuances.
I'll second it.
okay. All in favor? Say
Aye.
opposed, same sign. All right, then if we can move into the Executive Director's Office, Mr. Mock, would you give us an update, please?
Sure. Good morning. Tim Mock, Deputy Director for the Department of Natural Resources. Couple of updates this morning. One, the department will be testifying before the Joint Budget Committee today on the 23-24 budget. The draft wolf plan was released last Friday, December 9th. As we work to finalize and implement our gray wolf restoration and management plan, opportunities to attend live meetings with the Parks and Wildlife Commission and/or provide feedback online are available to the public. All of that is detailed on Colorado Parks and Wildlife's website. The final plan is expected to be adopted at the Parks and Wildlife Commission at its May meeting. Along those lines, we are now advertising for a Parks and Wildlife Director. That position is posted on the Colorado State Jobs website. It is open until January 18th. Board Member Singletary, you had a question last week about participating in that. We are still working on what the stakeholder process will look like, and like I said, we'll keep you posted.
Tim, I appreciate that. Appreciate it.
You bet. We're in the middle of interviews for an assistant director for energy innovation in the executive director's office. Hope to have someone on board around the beginning of the new year here. And then within CWCB, we've got two new regional water plan grant managers. These are individuals that will help, will be located in the four regions or the water basins around the state, assisting communities in applying for water plan grants. Lauren Duncan, who we all know well, was hired to focus on the Arkansas Basin. And Laura Spahn will focus in the Southwest Basin and Rio Grande Basin. We are also in the process of backfilling the marketing and comms director position vacated by Sarah Leonard at the Water Conservation Board. Also, the CWCB is working on finalizing the 2023 water plan update. The deadline for public comment and input has expired, and we are now working on addressing and responding to those comments. We'll produce a final draft later this month, and then planned adoption is at the January CWCB meeting. And then finally here, we had a native fish canal salvage. Every year as the water year winds down, irrigators begin to shut off their canals as they prepare for winter. And we've got fish that enter the canals from the river during the irrigation system season become stranded and will die if they aren't removed. So we had a crew out there salvaging bonnytail and razorback sucker. In all, about 3,500 native fish were salvaged and moved back into the Colorado River. And that concludes my updates. If there's any questions, thank you.
All right. Any questions for Tim? Thank you, Mr. Mock. And if not, we'll move to Ms. Brannon for the division, please. And thank you.
Yes, good morning, Ginny Brannon with the division. Yeah, a couple things. One, as you know, Jim Stark left us to live a happy ever after life with the Office of Surface Mining. And after 31 years with the division. And so Jason Music is now in that position where he'll be helping to shore up the coal budget problems that we have in light of reduced federal funding. And Carly Jacobs in the executive director's office has very, very graciously offered to help work with Jason and I to shore that up. So, and then so that left a vacancy in Jason's spot, which is the senior position. And we have promoted Amy Eichberger to that position. She has a BS in geology, an MS in geology, and she's been with the division for about 9 years. And so wish her great luck with the senior position. I'd have her stand so you could all see her, but nobody else except families here. So I think that's probably not necessary. She's been in front of the board before, so you'd recognize her. And I think that's about it. I do apologize and have to leave early today. I do need to go across the street for the Joint Budget Committee. We don't expect DRMS to be at all in the spotlight. However, I of course need to be there in case there are questions. So if I can ask your pardon in advance for that.
All right. Thank you and good luck with that. Any questions for Ms. Brannon? Mr. Means, any comments today or are you good?
I'm fine. Thank you.
Right. All right.
I'll be presenting later.
Perfect. All right. There's one item on the consent agreement for Asphalt Specialties. Any comments or questions on a 90-day extension for them, which would give them till March 13th, 2023?
Motion to approve the consent agenda.
Second.
Approved. All right, all in favor?
Aye.
Opposed, same sign. Okay. Now the move into a board action. And I believe Mr. Cunningham has a presentation on this for us first to start off with.
Hey, Jill,
Yep.
did you want me to just kind of run through the rules and process for declaratory orders for the board?
Yes, please. And if it's appropriate to do it before Michael starts, please go ahead.
Yeah, so the board gets these sort of requests not all the time. And so just to refresh the board's memory on how the process works for these, under the construction rules, it starts with 2.5.2. Kind of the initial question is for the board is, is this a petition that the board should rule on? There's a couple factors. There's a list of factors in the rule that can kind of help inform the board's decision. But one of them is this the sort of petition that if the board rules on it one way or the other, it would clear up, kind of questions or controversies about the applicability of statutes, rules, or board orders. there's several other, but that's kind of the key one to kind of think about here. Once the board makes that threshold decision of, do we rule on this petition or not, then it comes down to, the next step in the decision tree is how does the board want to proceed? So there are a couple ways to do that. The board can rule on the petition just based on the petition that was submitted. The board could order the petitioner to file an additional brief with more facts or information. It could move into a non-evidentiary hearing, kind of allow the party to present arguments about why they, their position on the petition. Ask the petitioners to submit additional facts in writing, or go ahead and set it for a full evidentiary hearing if there are more facts that the board feels it needs to hear. So that's kind of the rough outline. Depending on the information in a particular petition, some are easier to decide. There's enough facts to move forward once the board gets to that position. But kind of roughly that's the process that the board's looking at whenever it gets a petition for declaratory order. Question one, is this even a petition that the board should rule on? And then if the answer to that is yes, how does the board proceed? Does it need more information, or does it need to just hear from the parties? And essentially that's kind of the process. It doesn't need to be overly complicated, in spite of there being 5 or 6 rules on it. That's kind of the process that we're looking for. So any questions from the board on sort of the rules behind petition for declaratory order?
And we could today, I guess the question would be is if for the non-evidentiary hearing, we can proceed directly into that if we believe the situation warrants.
Yeah. The parties here, no reason to delay or kick it down the road if it's not necessary.
Okay. All right. Any questions from the board? All right, then, Mr. Cunningham, would you take us through this?
Yes, ma'am. Good morning, Madam Chair, members of the board. My name is Michael Cunningham, representing the division. And I've just got a brief introduction here to set the table, if you will, before I turn it over to Weld County. Early November, I think we started some conversations with the county. They reached out seeking some clarity as to the need for permits for roadway construction projects that fully take place within the right-of-way. We clarified for them that in those situations where material is mined or borrowed and utilized for a construction project, and all of that activity occurs within the right-of-way, no permit is required from our office. The exception would be if a borrow area is needed outside of that right-of-way, we would then work with the county on a 111 reclamation permit. Through those conversations, we learned that sometimes on these roadway projects, unsuitable construction material is generated, and the county needs to offload that, and they have done so in a variety of different ways. From there, the division directed them to submit an is it mining questionnaire to gain a little bit further information on these projects, the volumes of material involved, and we received that on November 4th and assigned file number M 2022-045 to this. After looking at this is it mining questionnaire, we continued our conversations with the county. As the board may be aware, our standard process is to issue a formal determination on that is it mining questionnaire. We did not do so in this instance. The conversation kind of progressed a little bit quickly, but in discussing this with Weld County, staff made it clear that our position was this would require a permit. We were in a situation where material was being removed from its natural occurrence, potentially transported and introduced into the market. And we have required permits for scenarios with a lesser level of activity in the past. So at our direction, we guided them to submit a petition for a declaratory order to seek exemption for removing small quantities of unsuitable construction material from these right-of-way projects. And that's the petition that you have before you today. One last thing I just want to point out for the board is that something similar came before the board a couple of years ago. In late 2020, the board considered a petition from Conejos County. It was a little bit of a different scenario, but in that situation, they were removing borrow material from above ground reservoirs, hauling that off-site and utilizing it for another purpose. In both scenarios, we had assurance that reclamation would be completed, or other performance and financial warranties and permits in place, such as stormwater permits. So we had an assurance that this was going to be completed. There was a public benefit to it as well, and really mining was incidental to the main intent of the project. So we were in support of Conejos County's petition for a declaratory order, as we are in support of Weld County's petition. And I think with that, I will hand it over to the county. We have Mr. Kimmey, I believe, on the call today, who can speak for the county and the specifics of this petition. But I'm available for questions if the board has any.
Thank you. All right. Mr. Kinney, are you here for on behalf of Weld County?
Yes, I am. And I can answer any questions that you have, and I can also give a little more background on how this question came to be and how I started talking with staff at the DRMS.
If you would, so briefly.
Okay. We have previously been operating under the guidance from DRMS that was given sometime back around 2010, 2011 timeframe, where I had a very similar discussion with the person that was previous to Michael. And at that time, we had been told that as long as the material that was leaving our construction area was not used for, or was not sold off and made a profit from, it would not be considered mining. So that's the assumption that we had been operating under for the past several years. And then just recently it came to our attention that that might have changed. I reached out to DRMS and asked the question and got a slightly different answer. And so we're here to ask for an order that exempts our construction projects that are occurring within Weld County right-of-way to be exempt from the 111 permit. We realize that any borrow material coming onto the site would require a 111 permit for our contractors. We're solely looking at when we have unsuitable materials, whether it be materials that are full of organics and can't be used in the roadway embankment construction. Sometimes we run across materials that are high in sulfates, which make it not suitable for roadway construction because the high sulfates will tend to erode or corrode the pipes, the culverts that we have to put in the ground for drainage. And then other cases, we run across expansive clays that have to be removed from the site. And historically, when those have been removed, if there's a landowner that's close to the site that wants the free material, we truck it to that landowner and give them the material for free. The county nor the contractor makes a profit over getting rid of the unsuitable materials. And we're not processing any of the materials. It's just taken straight out of the ground and removed from the site. So that's kind of how we are, where we are today. And if you've got questions, I can attempt to answer them.
Questions from the board?
Yeah, Madam Chair, just a quick question here. Thank you, Mr. Kimmy, for that background information. Is the reasoning just to kind of expedite, I know rural counties, having capacity, just trying to get work done as quickly as possible, or what is like the main reason to seek this petition?
Well, the petition is basically being sought so that we're compliant with the rules and regulations of the board or the DRMS. We're not processing the material. In my mind, it doesn't meet a mining definition because the materials aren't being processed. We're not selling the materials. We're giving it away to a willing landowner that might be wanting to use it to level out a spot in a field. And if we follow the rules of the DRMS, these types of construction projects have a very far reaching effect on all roadway projects done by CDOT or any other county or city in the state of Colorado. If we have to get a 111 permit to export material that is essentially a waste material from the job site.
Great, thank you.
Something I heard you say was that these, especially the expansive clays, that given free to local landowners, and when not, they may be something other may be done with them to cover costs.
The materials become the property of our contractor, and the contractor includes in their costs what it's going to take to remove those. And so when they tell us that they want to remove some of this material from the job site, we make sure that they are not selling the material to an adjacent landowner, so that they're not essentially double dipping and making an extra profit. Because when they bid the job already includes the cost of exporting that material away from our job site.
Thank you. Okay. So at this point, I think the board, per our attorney's advice, the first step is to decide if we want to rule on this petition or not. Any discussion or questions around that from the board? Any
Madam
motion?
Chair, I'd make a motion that we move forward on a petition.
Okay, thank you. Do I hear a second?
Second.
All in favor, say aye.
Aye.
Opposed, same sign. All right, so now we're into step 2. We can go through the various options. Would it be helpful to go back through those again for the board's clarification? Or are you in?
Not for me. I'd like to make a motion to accept the staff's posture on this issue and approve the declaratory order exempting Weld County Public Works roadway construction and maintenance project from Rule 1.4, which requires a 111 special operations mining permit.
All right,
Second.
thank you. All in favor?
Aye.
Opposed? All right. Well, thank you very much to both the division and Weld County, and motion has been passed for the petition. And of the declaratory order to Rule 1.4. All right. Next item is an enforcement hearing for High County Repair. Mr. Lundberg, do you have a presentation for us?
I do. Madam Chair, do you want us to be sworn in?
Oh, yes. Will all the parties involved in this matter swear to tell the truth?
Yes, yes.
Yes.
Thank All right, please proceed.
All right. My name is Patrick Lindbergh, and I'll be representing the division in this enforcement hearing. The enforcement hearing is for the Ghost River Gravel Pit, M 2003-002, permitted to High Country Repair. For the consideration of a possible violation, cease and desist order, corrective actions, civil penalties, permit revocation, and finding the financial warranty subject to forfeiture for failure to comply with the conditions of the board order, permit, or regulation. The Ghost River Gravel Pit is located in Orfano County, approximately 4.5 miles east of the last car exit, exit 64, east from I-25 on County Road 110. The permit is a 110C construction materials for 9.9 acres for the mining of sand and gravel. The post-mining land use is rangeland. The existing bond is $19,112. A surety increase, SI2, was issued on August 26, 2021 to increase the bond amount to $49,316. And that amount was due October 25th, 2021. This image shows the approved permit boundary in yellow, and the blue outline is the affected land boundary that was determined during DRMS's inspection, and it encompasses 11.8 acres. Here's another image that has a more recent aerial image that shows the more accurately reflects the disturbance to date. Brief chronology. On July 28th, 2021, DRMS performed a monitoring inspection and determined that 1.8 acres were affected outside the approved permit boundary. September 22nd, 2021, the board found the operator in violation for failing to protect areas outside the affected land from slides or damages occurring during mining or reclamation. On November 21st, 2021, that was the board ordered deadline for submitting the unsuspended portion of the civil penalty, $4,300. The amount was eventually paid on August 26, 2022. January 20th, 2022 was the board ordered deadline for submitting a conversion application. To date, the application has not been received. On April 20th, 2022, the board continued the enforcement hearing to July 2022 to allow the operator more time to gain compliance. Due to scheduling conflicts, the hearing for failure to comply was scheduled for August 2022. On August 11th, 2022, DRMS was informed of a dispute over who is legally able to represent HCR High Country Repair. The hearing for failure to comply was rescheduled several times to allow the operator time to submit proper documentation regarding who is legally able to represent HCR High Country Repair. On August 26, 2022, the operator submitted the unsuspended portion of the civil penalty in the amount of $4,300. On September 22nd, the operator submitted court documentation stating Natasha Goldberg is able to legally represent HCR High Country Repair. On October 4th, 2022, the division sent the operator a notice of continuance to schedule the board hearing for December 14th and 15th, 2022, to allow the operator time to submit the conversion application. On December 1st, the operator failed to submit the conversion application. Reasons for violation. CRS 3432.5-124 requires the permittee to comply with the conditions of a board order. The permittee did not comply with the conditions of the board's order for violation MV 2021-016 by failing to comply with the corrective actions required by the board's order. The original due date to submit the conversion application was January 20th, 2022. Therefore, failure to protect areas outside the affected land from slides or damages and failure to comply with the conditions of the board's order to correct such violation constitutes a default under the permittee's performance warranty. Staff recommends the board find the permittee in violation of CRS 3432.5-124 for failure to comply with the conditions of the board's order for violation MV 2021-016. Staff recommends the board reaffirm the cease and desist order issued by the board at the September 22nd, 2021 hearing, which prohibited any further activities on the affected lands, except those activities approved by the division in writing as necessary to comply with the conditions of a board order, prevent damage to offsite areas, complete reclamation, or to protect public health and safety until the corrective actions have been resolved to the satisfaction of the division. Civil penalties. In this manner, the board previously imposed a civil penalty of 43 days at $1,000 per day for a total civil penalty of $43,000. All but $4,300 of the total assessed civil penalty was suspended if the operator complied with the corrective action in the time specified. The division is not seeking any additional civil penalties in this manner. Staff recommends the board affirm the suspended civil penalty of $38,700 are due and payable. Staff recommendation for permit revocation. Pursuant to CRS 3432.5-124, parent 6, parent A, upon a determination after a hearing that a violation of a permit provision has occurred, the board may suspend, modify, or revoke such permit. Staff recommends the board revoke permit M 2003-002 pursuant to CRS 32.5-124, parent 6, parent A. Finding the financial warranty subject to forfeiture. Pursuant to CRS 3432.5-118, parent 1, a financial warranty shall be subject to forfeiture whenever the board determines that one or more of the following circumstances exist. A, The operator has violated a cease and desist order entered pursuant to section 3432.5-124. And if the corrective action was proposed in such order, has failed to complete such corrective action, although ample time to do so has elapsed. And or B, the operator is in default under the performance warranty and has failed to cure such default, although the operator has been given written notice and had ample time to do so. Staff recommends the board find the financial warranty for permit number M 2003-002 subject to forfeiture pursuant to CRS 34-32.5-118, parent 1, parent A, and parent B. Staff requests the board to direct staff to schedule a hearing for forfeiture of the financial warranty and send proper notice to the operator and the financial warrantor. Does the board have any questions?
Has the Natasha Goldberg been in communication with the division since the time of September?
We've had very sporadic contact with Natasha. She is here today along with some other representatives to talk to the board, but it's been very difficult getting communication and movement on this item.
All right, any questions for Ms. Goldberg from the board? Any comments from Ms. Goldberg that you'd like to say at this point?
So I had hired somebody to, can you hear me?
Yes.
I had hired somebody months ago to do the conversion for me, and my sister-in-law wrote an email and contacted Patrick stating that she was the owner of mine and my husband's company, who is deceased. So my guy that was going to do the conversion quit and didn't want to be a part of it. So after I had turned in the paperwork that I needed from the judge to prove her statement's false, I turned them into Patrick, contacted the guy again, Richard, I can't remember his last name. And he refused to do it because he didn't want to be a part of it. So I contacted several other agents afterwards while going to 4 other court hearings on behalf of my husband's estate. It took until my lawyer had found a new representative to find somebody. Everybody wanted $50,000 to $75,000 to convert this, which is something I cannot afford. The man, Rick Kidd, has stepped in. He has contacted Patrick. He has contacted a surveyor, B2H. Everything is going into place. He's waiting for surveys. So it's not like we're ignoring this. This is a matter of my sister-in-law stepping in and deterring everything that we were working towards a few months ago. And now we're trying to catch up to that and find people that will actually work with me because of her nonsense.
My name is Rick Kidd with Kidd Engineering Construction Management Services, based out of Avondale, Colorado. Mid to late November, Natasha's attorney, Todd Kettlecamp, contacted me, explained to me briefly about the project asked if I was, would be willing to step in and carry this through. I told Mr. Kelkamp that I would be. I have worked with Jody Schreiber with PFM Consulting on some other gravel mine operations. So I was familiar with her, contacted Jody to take care of the permit side. And she said that she was willing to work on that and that conversion. I contacted BH2 Land Surveying. I've worked with them on many projects. They've already been out and done the survey work so that we could have a definition of the disturbed area where we need to expand the boundary lines to. It's my understanding that Natasha is the owner of the affected real estate, so it'd be an expansion onto property that she already owns. I will take care of the slope stability analysis, and consider what needs to be done to stabilize what setbacks we need for the expanded boundaries, et cetera. Was in contact with Patrick about that right around Thanksgiving, and I told him that obviously we couldn't get this all done by the December 1 deadline, and he recommended that we appear before the board on this hearing today to discuss it. All we're asking is, as Natasha indicated, we just need more time. We're brought into this late, ready to jump and go on it. My understanding from Jody is that the conversion process permitting takes several months. Again, she's the one familiar with that, and you all are. I am not. All I know is what I'm told. But we are online, ready to get this move forward, get it done, get her back into compliance with her gravel pit. All we need is some additional time.
Madam Chair.
Yes, please.
Mr. Kidd, could you tell me again who you are, where you're located, and also who the surveyor is?
My name is Rick Kidd, Engineering Construction Management Services. I'm located in Avondale, Colorado.
Slow down.
In Avondale?
Yes, sir.
Okay.
Jill asked me to slow down, so I'll repeat again. My name is Rick Kidd.
Right.
I'm the owner of Kidd Engineering and Construction Management Services. My office is Avondale, Colorado. I have worked, the land surveyor is Bill Beachaver with BH2 Land Surveying out of Colorado City. He's the one that did the original survey work for the gravel pit operation boundary. And then also on the team is Jody Schreiber with PFM Consulting.
How much, maybe you kind of explained it. How much time do you think you need?
I believe, Jody, I've already got the survey work done by the 1st of January. I would hope to have the land stability analysis completed. So it's just a matter of how much time Jody then needs for her paperwork, send out notifications to adjacent landowners, receive their responses back, that whole permit process. My understanding from Jody is that this conversion is basically like going for a new permit. So have all those hoops to go through. So it's just the time involved in that.
And is Jody present today about narrowing that time in a bit?
Yes, I'm here.
Could you give a little bit more definition around what that time requirement is?
Jody, you're muted right now.
Oh, there we go. Excuse me. I would say it would take about a month to get the permit package put together. Following that, then obviously there are specific guidelines on the notifications, publications, and so forth, as well as adequacy reviews with Patrick. Depending on the speed of that, I would think it would take less than 6 months. And that's the far end. Obviously, I want to be very conservative. If there are any issues, any landowner structure issues that we need to delve into, I would say 6 months is the outside length of that project if everything goes well. But we could probably have a permit package to Patrick within a 30-day time frame.
Yes, because Patrick, am I correct in that we expected that on December 1st?
Yes, that's correct. We initially we were hoping to get it back in January 20th of 2022, but then yes, the December 1st due date, we're trying to hope to get something by that time.
So again, understand there's a bigger process behind that, but Jody, if you can speak to that, when will that application? Same thing with Kid Engineering. When will that application actually hit the division's desk?
I would anticipate within the next 30 days. If the survey is near completion, that usually takes the longest. And as soon as Rick has that slope stability information, a package could be sent over by the end of January.
The field survey work has already been completed. I have that information on hand. Did some topo work on that so we can figure out what slopes we're dealing with and the affected area. And after I determine slope stability, what we need to do for protection, then we can establish a new permit boundary. And I would expect that to happen within the next few weeks.
Okay.
Madam Chair,
Yes.
Tim Mock here. Mr. Lambert, the board already issued a cease and desist order.
Yes.
Was that followed or was mining activity still conducted on the site?
Mining was not continued at the site. The division is aware that entities have stated that she has continued to haul material out of that site that was stockpiled previous to the cease and desist order going into effect.
Is it permissible under cease and desist order to transport stockpile?
No.
Mr. Mock, yeah, this is Jerry with the division. Yeah, we've received some reports and we've gone out and done follow-up inspections and we haven't been able to basically catch them in the act. And so we have heard that they have hauled some material out of there, but we haven't seen significant evidence of that, and nor did we observe it ourselves. And no, it is not permissible under cease and desist order to do that.
Ms. Goldberg, has there been transport of stockpile since the board cease and desist order?
The man that was mining at my gravel pit for my husband before he died has pulled out several 100 ton after the cease and assist. And we've pulled out some fill dirt. Yes, we pulled out the scrap stuff. Like we had an old screening plant there that we pulled out. They pulled out all their equipment. So yes, there has been people in there. There has been movement in there. As for material, my company alone has pulled out probably 75 ton of material. And Ceramic has pulled out close to 1,000 ton of material after the cease and assist.
I'm struggling here a little bit to understand your request for leniency when our cease and desist order has not been followed.
I can't control Kevin Ceramic. After I spoke with Patrick about the cease and assist about pulling material out, my trucks have not been in there since.
So you have
Kevin
said
Ceramic has a lawsuit against me for this material. So he pulled out as much as he could with his trucks. Didn't know about it. I had a guy that is working at a gravel pit down the road off of Pickney Road that saw him with several of his trucks in and out of there for several weeks pulling out material. It's now sitting in his yard in Colorado Springs or Fountain, wherever his location is. Before he had pulled all of his stuff out there, I wasn't notified that he was going out there. He just took the material. I told him it was a cease and assist, and in turn, he's suing me for $75,000. So. But after speaking with Patrick about my trucks and material, when he came in person, I don't even remember what, July or August. My trucks have not been in since.
Is his site secure so his trucks can no longer come in as well?
There's a gate, but he had the gate code for that. And so, I don't have a new gate lock on there. I do have the gate there, but you can get in anywhere on that property because the gate is just, it's not like it's super duper secure, it's a tiny plot of land. So it's not 100% fenced off. You can get in at any angle, anybody can. So even if my gate is locked with a lock, anybody can still get in.
Trucks can still get in.
Yeah. But I can tell you that my trucks have not been in there since I talked with Patrick. And I assume that Kevin, since he's suing me, is not going back in there after he pulled all of his stuff and a ton of material out of there.
Okay, any other questions for Ms. Goldberg or from the board? Board discussion on this?
Well, I'm sorry, Madam Chair, I guess I've got one more question here. And I don't know if Ms. Goldberg or Mr. Kidd can kind of explain the lack of communication with division staff.
There hasn't really been lack of. I respond to Patrick's messages. I am dealing with my sister-in-law served me paperwork to take over my husband's estate. So I've been 100% occupied with that. I've also got a lawsuit from a truck accident from 2018 that's going on right now too. I have Ceramic suing me. And then I had another lawsuit. That one got handled. All of these all at the same time. I'm only one human. So that is why I can't respond every second of every day about what's going on. I have responded if there is something major that he needs to know, such as not being able to find somebody to do the consulting, such as my person that was doing my consulting firing himself from the situation. My lawyer's been involved. I've got the first, 6 or 7 months, I was grieving the death of my husband, dealing with my children losing their father. So, there's a little leniency would be great.
And as far as since that time when Tasha's attorney contacted me, I then gotten in touch with Natasha and with Jody to find out more info, about the conversion process, because I'm not familiar with permitting and that type of thing. So I talked to Jody about that, got her brought in as part of the team, and had Bill Beachaver with BH2 Land Surveying go in and do the survey work. And I already have that survey work in hand. So as soon as I was brought into the picture, things had been proceeding until we came up to where Patrick said we need to wait until this hearing to request the time, that he couldn't grant it to us. So we kind of stopped at that point, other than the survey work proceeded. So I've got that, we're ready to go.
Maybe it's a question for the division staff then, Mr. Lindberg. If we were to give them what sounds like they would need, 6 months to complete the paperwork? Am I hearing that correctly?
It would be 6 months to get the conversion completed and done. So that includes them submitting the materials and the correspondence back and forth. And then the final approval of the conversion application would take approximately 6 months is a fair estimate. It could go a lot quicker.
Madam Chair,
Yes.
going on with that, so if they turned in the necessary paperwork by, let's say, February 1 of 2023, you feel comfortable that we could accomplish this within this, say June 1st of or July 1st of 2023?
Yes, sir.
Okay, and sir, is there stuff on the site now that's a danger or something that needs to be taken care of? And if we were, where I'm unsettled on this thing continues to linger, and I understand problems, and certainly Natasha Goldberg has had her share. And our goal is to make sure we remedy these things as best we can. And if we can find a course that they're suggesting, I'm not comfortable with it, because they haven't shown, as Mr. Muck brought up, they really haven't shown a lot of I guess they're showing it now because they've actually got some people in place that could maybe make this thing happen. I just staff, are you comfortable with letting it sit out there the way it is till July 1, let's say? I know the property. I know. In fact, Mr. Kidd, I'm in Vineland, Colorado right now, so I'm really close to you. So I know the players and what's going on. But I know where the property is, and I'm not familiar with this exact site. But staff, what's your thoughts? Have you got some thoughts that if we continue to try and figure out something between now and say July 1, what do we need to do?
Yes, this is Jared Ebert with the division. We're empathetic with the situation, and we know there's been a lot of legal back and forth that's been going on. But like you said, we are hesitant about the path forward. We think there should be some pretty stringent sideboards to this. We think it would probably be permissible to allow them some additional time to submit the conversion application. What I heard from Jody Schreiber and Mr. Kidd is they could probably get that application to us within the next 30 days. So I think that's definitely reasonable to allow that. We would maintain, though, that the board still find a violation, and that the permit should be suspended in accordance with 124 per and 6 per and A, I believe. So to make it very clear that they do not have a permit to continue mining operations out there, and should additional deviation from the cease and desist order occur, they will then be, basically mining without a permit or without permit. In which case that carries with it even more stringent civil penalties and corrective actions and whatnot. And we obviously want the cease and desist order to be maintained, and that the board should also find the financial warranty subject to forfeiture. So that way, if the board does extend the deadline to submit the conversion application, if that is not accomplished, we can then just proceed right to final forfeiture. So we don't have to keep coming here for this same violation multiple times. Does that make sense?
Yeah, sort of. I somehow we're going to have to, we're going to have to be realistic about people hauling material out of there during that period of time. It sounds to me like there's, either, I don't know how we supervise that, but if somebody's doing that, somebody needs to call the sheriff in Werfenau County and make sure that doesn't happen. And we can't let this kind of linger on and people just come out there and load up and haul off material,
Yeah, agree. It does seem to be the burden of the property owner.
The only thing I can suggest for that to stop is I'll need to send one of my guys in there and remove the loader out of the property. Because it is an old loader and it will start without a key. So,
yeah.
And that's been the equipment that's been used to haul material out?
yeah, anybody can start it.
What's that?
Anybody can start that loader. It's like a 74. I don't even know what model it is, but it's old.
Yeah, you need to get that out of there. Gee whiz.
Yeah, if you've removed everything else.
As long as I'm able to move that piece of equipment out, then the only way somebody can load is if they bring in their own machine.
And for the division, I believe under the cease and desist, they would be allowed, that activity would be allowed to occur.
Yes, removal of that equipment would be allowed. We'd be okay with that.
Does the division have any, what is your position on affirming this suspended penalty? Civil penalty?
I would say that it should be maintained as suspended until they are unable to comply with the corrective action in its entirety, submitting of the conversion application and then getting it approved within statutory timeframes.
Okay, and then also with this application, we will expect, one of the comments somewhere was that there was insufficient surety bond, that would be recalculated as part of that approval process.
That is correct.
And Ms. Goldberg, you're aware of that surety will increase with that application?
What does that mean for me financially?
We don't know yet.
Is that something I need to do with my insurance, or I don't understand, I guess?
You have Ms. Goldberg, you have a reclamation bond in place for this site. I don't know if it's, what is it, a corporate surety or is it a letter of credit?
I think it's a cash bond.
It's a cash bond, okay.
It's a cash bond.
So you have a financial warranty posted with the division, and that covers the costs the state would incur if we do forfeit the financial warranty. We cover our costs to do reclamation. Right now, the amount that we have calculated is, the amount that you have posted is not sufficient for us to do reclamation. And so through the conversion application, your reclamation plan for that application, you will present to us how much you think it would cost to do reclamation. The division will evaluate that, and we will set a new required financial warranty amount in the amount to do reclamation based on your new plan with the conversion. And so whatever that amount ends up being will be what you will be required to post. So likely it will be above the amount that you currently have posted in the amount of $19,112.
But that's part of the process of getting the new permit. You guys will sit down and visit about what that liability could possibly be. So that's just part of the permitting process, correct?
Yes, sir.
Does that answer your question, Ms. Goldberg?
So I need to come up with another bond through my insurance company, or I need to create $20,000 somehow and get another bond? So no, I guess it didn't answer my question.
As of right now, the thing is to get the conversion application submitted. Then we can do a calculation and we can go back and forth on what the bond should be. And once we get that figured out, then there are multiple mechanisms you could do to post that additional bond. Sometimes it's through an insurance company, sometimes it's through a bank, or it could be cash. So we're a little bit further out from that happening to be posted, but it is good to have that on your radar, that is in front of you.
Okay.
To be clear, Ms. Goldberg, that's just what you have to sit down when you're talking to the staff here. They're going to go over the different requirements, and one of them is what their prospective liability might be if they have to reclaim this thing. And so you can sit down and say, and that's just part of the process. We don't know if it'll go up or not. It probably will. How much is still open for debate and discussion. So, I mean, yeah, you need to think about it, but there's ways to get there if you get all the other stuff done.
Okay.
Okay. Go ahead.
I'd make a suggestion. If we took like a 5 or 10 minute recess and requested the staff to write what they would like us to make a motion on, I'd feel comfortable with that. Maybe we can get Mr. Fugate. I mean, we don't need any more words than necessary, but if they would write up a proposal on what we could look at to make a motion on, I'd suggest that.
Does that change any other than adding a deadline for extending the debt requirement for the conversion application?
I don't know.
I-
Something
yeah, I
like there
think-
were some things in there the staff wanted that were outside of. I'm not sure. That's something I would like them to clarify. I want to do.
Certainly.
I'm in agreement with what their wishes are, but I'd like to see what it is.
Yes, this is Jerry with the division again. I believe the recommendations that we have listed out here are the same recommendations that we would give you.
Okay.
The change we would make is with the civil penalty is, continue to have that suspended in order for them to comply, give them a chance to comply with the corrective action. And then I would just give them, the only thing I would add is for corrective actions, to just put a deadline, maybe 30 days from the signature date of the board's order to submit the conversion application. And in terms of permit revocation, the staff would recommend the board, as opposed to revoking the permit, would suspend the permit and still find the financial warranty subject to forfeiture. So the rest of those recommendations on the sheet are the same. The only thing in addition to it would be the extension of the corrective action.
Considering that we're at the Christmas, New Year's holiday season and I'm having cataract surgery next week, instead of 30 days, I would like for that to be February 1. That's
I
my
agree
only
with that.
request.
That's
I
fine.
agree with that.
And just one point of clarification there is, 30 days from the signature date of the board order, it usually takes about 3 to 4 weeks for the board order to get signed from today's date and then submitted. So, that 30 days ends up being closer to 60.
Keep the February 1st then.
February 1st. Okay.
Okay. All right. In the essence of time, Mr. Singletary, are you okay proceeding?
Yeah, except I don't have in front of me and I don't know where it is. Somebody else needs that material that they just said, Pat or Tim, do you have it to make a motion with?
I will take a shot with staff's help here at a motion.
Well, you at least got it close to you. That's good.
Yeah. All right, so I move that the board find the permittee in violation of CRS 34-32.5-124 for failure to comply with conditions of the board order for violation MB 2021-016. Good so far, right? That the board reaffirm the cease and desist order issued by the board at the September 22nd, 2021 board hearing, which prohibited any further activities on the affected lands except those activities approved by the division in writing as necessary to comply with the conditions of the board order, prevent damage to offsite areas, complete reclamation, or to protect public health safety until corrective actions have been resolved to the satisfaction of the division. The board further affirms the suspended civil penalty of $38,700. Would that be correct? Yes. And that the board revokes permit number M. Is it revoke or suspend? This is just
Suspend.
sorry. The board suspend permit number M-2003-002 pursuant to CRS 34-32.5-124 parent 6 parent A. And that the board find the financial warranty for permit number M-2003-002 subject to forfeiture pursuant to CRS 34-32.5-118 parent 1, parent A, and parent B. And are we directing staff for the hearing for the forfeiture financial warranty?
Should they not comply with the correct?
Yeah, and that we direct staff to schedule a hearing for forfeiture of the financial warranty and send proper notice to the operator and the financial warrantor if
if they fail to comply with the corrective action.
if they fail to comply with the corrective action, and that the corrective action be performed by February 1st, 2023. And that the loader be removed. Should we add this one in there? And that the loader be removed from the property. Ms. Goldberg, can you get out of there in 2 weeks?
Yes,
That the loader be removed by January 1st, 2023. Anything else? There's my motion.
I'll second it.
All in favor, say aye.
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 Opposed, same sign. All right. Thank you, staff and Ms. Goldberg and your consultants, and we wish you the best in getting this taken care of.
thank you.
Thank you.
All right, now into the enforcement hearing for file number P-2013-019. Were all those people willing to testify in this? Please swear to tell the truth.
Yes.
Yes.
All right, and we will turn this over to Patrick Lundberg, please. You're on stage today.
Yeah. Good morning, members of the board. I am Patrick Lundberg, and I will be representing the division in this matter. It's an enforcement hearing for the Badger, a group of mines, NOI number P-2013-019, permitted to K&B Mining LLC. It is an enforcement hearing for the consideration of possible violation, civil penalty, cease and desist order, corrective actions, permit revocation, and finding the financial warranty subject to forfeiture for failure to maintain legal right to enter and for failure to timely reclaim affected lands within 5 years of the completion of prospecting activities. The NOI is located in Boulder County, approximately 1.8 miles east of Jamestown, Colorado. As mentioned before, it's a prospecting NOI for approximately 1 acre for the prospecting of gold and silver. The NOI is located on both private property as well as U.S. Forest Service land. The current financial warranty of $11,426 is adequate at this time. Here's a map that shows the approved NOI boundary. The polygons outlined in red are patented mining claims owned by Collider Mill and Mining, who is owned by Pat Farr. The NOI permit boundaries are outlined in the black polygons. As you will note that the black polygon by portal number 2 is on U.S. Forest Service land, and the transfer location is located on private property. Here's another location map that shows the Rip Van Dam property outline on the upper right-hand, towards the upper right-hand corner of the map, and then the U.S. Forest Service 287.1 road comes in from the left-hand side and kind of meanders its way around and crosses the private property a couple of times. The black polygon on the left-hand side center is the approximate location of the private property. Brief chronology: on September 12th, 2022, the division received a citizen's complaint from a landowner, Eric Harms, about trespassing across private property and possible illegal mining activities within the area of the Badger Group of Mines NOI in Boulder County and nearby land. On September 15th, 2022, the division performed an inspection of the area with the landowner, followed by an inspection with the individuals that were subject of the complaint. Staff also inspected portions of P 2013-019. On October 3rd, 2022, the U.S. Forest Service issued a letter stating the plan of operations for P 2013-019 expired in November 2015, along with authorization to use Forest Service roads in the area. The letter also stated the operator needs to demonstrate legal access across private property before a new plan of operations can be considered. On October 5th, 2022, the division was contacted by the landowner about ongoing activities at the site. On October 7th, the division received correspondence from the U.S. Forest Service regarding those ongoing activities at the site. On October 19th, 2022, the division sent the operator a reason to believe a violation exists and notice of board hearing. On October 30th, 2022, the division received correspondence from the complainant's legal representative regarding their position of access to the U.S. Forest Service road across private property. This is a photo of U.S. Forest Service Road 287.1 as it crosses that private property. This is a photo of the Rip Van Dam portal located on U.S. Forest Service land. This is part of the NOI location. This is another photo from a different angle of the same location. Reasons for violation. The permittee does not have an access agreement to cross private property to access the NOI. Additionally, the U.S. Forest Service Plan of Operations granting legal right to enter to conduct prospecting on U.S. Forest Service lands expired in 2015. Failure to demonstrate the legal right to enter is a violation of Hard Rock Rule 5.1.2 D parent 6, which states the permittee is required to demonstrate the legal right to enter to conduct prospecting and reclamation. According to the permittee's submitted annual reports, prospecting activities have not occurred at the site since either April 2014 or September 2016. Pursuant to Hard Rock Rules 5.3.1 parent G and Rule 3.1.3 parent 2, reclamation must be completed within 5 years of the completion of prospecting activities. CRS 3432-116 parent 7 parent Q states all reclamation shall be carried to completion by the operator with all reasonable diligence. Staff recommendations. Staff recommends the board find the permittee in violation pursuant to Rule 5.1.2 parent D parent 6 for failure to maintain legal right of entry. Also find the permittee in violation of Rules 5.3.1 parent G and Rule 3.1.3 parent 2 and CRS 3432-116 parent 7 parent Q for failure to complete reclamation within 5 years of ceasing prospecting activities. Staff recommends issuing a cease and desist order prohibiting any further prospecting activities except those activities approved by the division in writing as necessary to comply with the conditions of the order, prevent damage to offsite areas, or to protect public health and safety until corrective actions have been resolved to the satisfaction of the division. Corrective action. A, require the permittee within 90 days of the effective date of the board's order to demonstrate the legal right to enter across private land and obtain a new plan of operations from the U.S. Forest Service to complete reclamation at the site. Within 180 days of the effective date of the board's order, complete reclamation of the affected land. Civil penalties. Pursuant to CRS 3432-124 parent 7 and rule 3.3.2 parent 2 parent B, a person violating any provisions of a permit issued under this article shall be subject to a civil penalty of not less than $100 per day, nor more than $1,000 per day for each day during which such violation occurs. Civil penalties. In this manner, the board may fine 56 days of violation from October 19th, 2022 to the December 14th, 2022 board hearing, resulting in a civil penalty range of not less than $5,600 and not more than $56,000. Staff recommends the board assess a civil penalty of $200 per day for a total civil penalty of $11,200, with all but $1,000 suspended if the operator complies with corrective actions. Payment of the unsuspended portion of civil penalty shall be due and payable within 30 days of the board's order effective date, unless otherwise specified in the board order. For corrective actions not completed by the date specified in the board's order, the suspended civil penalty shall be due and payable within 30 days of the board ordered deadline for completion of corrective actions. Does the board have any questions for staff?
Any questions? The permittee has been submitting their annual reports on time.
That is correct.
I guess I had my microphone muted. Can you hear me?
Yes, sir, we can. Can you? And did you testify that you tell the truth if you speak before the board?
I do.
Thank you, sir.
I'm sorry, can you please identify yourself?
Yes, my name is Pat Farr, Farr. I am the owner of the property in question, and I've owned that property for 51 years. I have never had a problem with access until about 2 months ago, when the new owner acquired the Higby Placer, which is where the access of Forest Road 287 joins James Canyon Drive. I've never had a problem going over that road. And recently, I advertised that property for sale. And I gave the buyer, or the potential buyer under contract, a key to go look at the property. It appears that in the process, they were unlocked the portal to the mine shaft. They went in and was removing material from inside, which I didn't really give them any permission to do that, but they are a potential buyer. And in the process, they went across the road in front of James Harn's house. And Eric Harns rather, and he was the one that filed a complaint. And I live in Fort Worth, Texas. What's happening up there at the property in Jamestown has been a kind of a fiasco ever since I ended up with K&L Mining NOI permit. I ended up with that permit in 2017 because the owners at that time were leasing the property and were doing core drilling. Now, I had in November of 2019, about $160,000 worth of equipment stolen from the site. The locks were cut. The entry to the mine shaft was, the locks were cut, and somebody put their own locks on my property's gates. So when I get a report that I am in violation, I'm all in favor of whatever needs to be done to rectify those violations. I have talked to Patrick. He went out and investigated the site, took pictures, and you know, I have not been up there to see what's going on. I did have my geologist who I've had employed, who lives in Boulder, for 5 years, to go up and see if there was a spill, which has been reported that a spill took place somewhere on the property from a 55-gallon drum. And my geologist sent pictures back and stated that he could find no evidence that there was any kind of a spill. Now, what I want to say to the board is that whatever you decide, I am aware that I have no permit, that the permit has expired. I am aware that there is a bond up to take care of the reclamation. I am aware that the reclamation involves about less than an acre. I am aware that the bond amount was set by DRMS Cunningham back in, I think, 2014 of 11,000 some odd dollars. And that money is still up. I do think that I can probably reclaim that area for much less than that because of the amount of acreage involved. And I do not have access to get to the property because I got a letter from Eric Harn's attorney stating that I would be trespassing if I went over the Forest Service road, which I have never had that problem. So it does appear that in order for me to legally have access, I'm going to have to hire an attorney and have some court to tell me whether I have access or don't have access to my property. I have claimed in the past that I have access to that property because it's a Forest Service road. And for 51 years, I've never had a problem going over that road until the last 2 months. So basically, that's my statement. And I realize that the board has a responsibility to do whatever they feel necessary. I do want to say that the snow is on the ground up there probably now maybe 1 to 2 feet. It would kind of be impossible to go up there and do reclamation now. I do not have any consent from Eric Harns to go over 287 in front of his house, which I guess I'll have to get an attorney to resolve that issue. And I don't know how long that would take. I do think that with my experience in the past, it would be May or June before we could actually get up there to do any kind of reclamation on the property. So that's where I stand. Now, is there I may have rambled on a lot, but I'm basically unaware of what's going on up there other than just my long distance information. So that's what I have to say about where my position is. I got the notice that there were possible violations. What Patrick has recommended, I have not been privy to that until now. So if you have any questions for me, I'd be glad to answer anything I can.
No, Madam Chair,
Yes.
Pat, you mentioned that you had a potential buyer. Is that going to be held up because of all this, or what was the buyer's interest? Do they want to? I mean, do they want to be an ongoing operator, or what? I mean, is that a real thing, or do we need? I mean, we got to deal with something right now, but maybe tell me a little bit about what you think there.
Well, I have no intent of doing any kind of operation on the property. So I inherited that NOI from K&B Mining in 2017 because I invested about $250,000 in that LLC. And that's how I ended up with the K&B Mining. I have not done it. No activity has gone on that property since 2016. Other than the potential buyer going up there and supposedly taking material off the property. I do not intend to renew the permit. What I do want to do is to get access to my property. And it looks like that's going to be a legal battle between me and Eric Carnes.
If you indeed get access to that property, then are you going to reclaim it?
Would you please repeat that again, please?
If and when you do get access to your own property, will you be in a mode to reclaim it?
I certainly will.
Okay.
And that the reclamation has been identified in the permit when the bond was put up. So the area that is to be reclaimed is less than an acre, and it's in front of the portal to the mine. And since that permit was issued, there was the flood of 2013 that washed a lot of the mine dump down the creek, which nobody could avoid that. But I would have no problem of reclaiming it when I'm able to get to the property.
And you mentioned that you thought you could do that, including the mine dump reclamation within the $11,000 as soon as you're able.
Yes, I can.
And I'm sure that would hopefully take care of any legal fees you might have to gain back access.
I have no idea how much that's going to cost.
Okay.
It's a problem that that I didn't anticipate. When I called the Forest Service, I was under the assumption that the Forest Service, according to Boulder County Transportation Department, had the oversight or the authority of that road. The Forest Service tells me that that private section at the intersection of James Canyon Drive is not under their jurisdiction. It's private land. And I've never heard that before. I have more private land on that road than Eric Harns does. And I've had that property for 51 years. And it's the only access to my property. And I have a lot of legal rights to access because at one time, my property and Eric Harns' property was owned by the same individual. And the right of access was never a problem until Eric Harns buys the property and then don't like people driving up Forest Service 287 where it intersects with James Canyon Drive. He knew that when he bought the property. But you know, I never thought that there would be a problem of accessing my property using Forest Service Road 287 where it intersects James Canyon Drive. But apparently I do have a problem.
Sir, is it your intention to regain access and finish the reclamation before you sell this property?
Nobody that I know of in their right mind would buy that property with what's going on now. I would not want to sell that property until I could assure the buyer that they had access to the property.
So is the potential,
Excuse me.
is the potential buyer that you mentioned not interested anymore?
Well, the potential buyer, I have a contract with them. They have paid me money. They have a key to the property. They live in Black Hawk, and they have been forbidden to use the road. Now, they will not contact me because they're delinquent with their payments. And that's another problem that I have to, settle with them. And, but I'm, whatever I have to do, I will do. But the time-wise now, because of the weather and because of the condition of the road, I don't even know if you could get up to the property now because of the snow. So I don't know, did I answer your question?
Yeah, thanks.
Madam Chair, if I could ask staff, is it reasonable that you can get up there and perform reclamation within the 180 days?
That would be 6 months. I should be able to get to the property by May of 2023, and that would be within the 6 months period, wouldn't it? Yes.
Yeah, I think that access to where the NOI is located to perform reclamation, they could probably get access by May, June timeframe. I think the biggest hiccup's going to be the legal right of access across the private property.
Well, even if the bond money that's up would be that if the state had to reclaim it, they would have the same problem of getting a contractor up there doing what needs to be done. And I can do that because even though I'm 85 years old, I have spent 41 years in the construction business. So I think I know how to get the reclamation done by using a local subcontractor to comply with everything that needs to be complied with to reclaim the property. But I do have to get access. And that is a legal problem at this stage with Eric Harns.
is there, let me ask a question for staff then, in regards to the 90 days for the legal access. I think what we care about is the 180 days that you get reclamation. Is there a reason for the 90 days, if it is kind of tricky, that we couldn't just make them all both one and the same 180 days?
We could, yes.
Say that again, please. I'm having trouble hearing you on my computer.
Yeah, I was just asking staff to explain if there's a reason why we couldn't just set the 90 days to get right of access, make it consistent with 180 days in the reclamation of the site.
At this point, I do not know how long it's going to take to get legal access. That, according to the information that I've been given, is going to be a legal decision by the court. And I have no control over how long that might take. That's the
I guess
information that my attorney has given me.
if Mr. Harms doesn't have access, we won't have access either.
Well, that's what I asked the Forest Service. I says, if I don't have access, how do you have access? Well, the Forest Service, I thought, had jurisdiction of that road, period. And that the private owners were in a situation. It has never been a problem for me having the Forest Service access over my property. And I've got about nearly 3,000 feet of forest road 287 on my private property. The guy at the entry has about maybe 1,000 feet, but it's at the intersection. It is where you have to access the properties that he has the right to. Well, he's first in line there at the intersection of James Canyon Drive. So I never had a problem before, and I really don't know how that's going to end up, but whatever it takes, I will make that happen. I just don't know how long that would take to get it legally in writing.
Mr. Singletary, this is Russ Means for the division. Just a point of clarification. The inactive mines program, if we have a revoked site, they go in and one of the first things they do is work with landowners and stuff for temporary permission to go in and do reclamation and stuff. So that's part of their process and stuff when they take over a revoked site. So I just wanted to make that clear. So
Can we lend him a hand and get him access to go in and reclaim it?
I can't answer that honestly. I don't think so. That's kind of outside of our jurisdiction and that because for us to negotiate that for somebody else.
I guess what troubles me is I think this gentleman's trying to do the right thing, and I think we need to help him if we can. And I appreciate his honesty. He's been forthright and honest about where he sits, and I appreciate that. And if there's anything we can do, I can't believe that the Forest Service wouldn't help out on this situation. And all we're trying to do is get that reclaimed and get it back to where we want it. And this gentleman at least has come forward with us and said that's what he wants to do. So I guess the frustration is we need to, if we can help him, let's do it. I don't know whether we can or not, but I'm frustrated about, this is why people don't like government.
Mr. Singletary, perhaps, I'm sorry, Madam Chair.
Mr. Farr, did these troubles start with, I assume that over the course of years, you've had access pretty freely going over.
Absolutely.
I
have had no problem with access for 51 years. Until about 2 months ago.
And did that trigger from these potential buyers?
Yes.
going into this situation, is that the source of conflict?
That is correct.
So if that's removed, can your relations with Mr. Harms and Axis be repaired for the sake of closing this up?
Well, it could be, but the next buyer would have the same problem. The problem that I have with the property there is that I have rocks in that mine that have assayed over $1,000 a pound. So I can see why people want to go up there picking up rocks. That information was obtained by core drilling from inside the tunnel in 2015 by the people that had K&B Mining. They were the operator. When I ended up with K&B Mining, nothing took place after they left in 2016. Now I'm trying to sell that property, but I don't want to sell the property until the new owners have access to the property to do whatever they want to do with it. And I don't think Eric Carnes would appreciate having trucks running in front of his house. Whether it's me or, I wouldn't do it, but the new buyers probably would, because that's the only access they have to the property. So I need to get legal access to the property to use Forest Service Road 287 to my property to do whatever needs to be done by whoever wants to do what they do. And that's going to involve mining eventually. I am aware that not too many people in Boulder County want a mining operation going on. I understand that. But when people spend millions of dollars on a piece of property, they expect to make money. And that I don't want people to feel like that they're buying a piece of property just for the real estate. They're buying the minerals because that's where the value is on my property.
Madam Chair, this is Russ Means for the division. Perhaps a course of action and stuff for the board to consider is finding the violations and stuff and that, and then putting everything out at 180 days with the condition and stuff that if Mr. Farr needs additional time beyond that, he can come back before the board and make a request and stuff for further extension and stuff and that, and report back to the board. There's a lot of issues here and stuff that are outside the jurisdiction of the board and the division that we don't have any control over. And we understand that. We also understand Mr. Singletary, I agree and stuff that, Mr. Farr is trying to do the right thing. So, but maybe perhaps giving him 180 days to try to sort it out and get things accomplished, it would be great. And if he can't do that, then he can come back and revisit this with the board and stuff and that right prior to that deadline. And that's my recommendation.
Well, I do believe that the board would not have a problem getting access to the property to do the reclamation. Now, I agree that I may have a problem getting access because I am in conflict with who has jurisdiction of that road across private property. I've always thought that the Forest Service had jurisdiction. I have never thought that the private landowner had jurisdiction of that Forest Service road, regardless of how much they owned.
All right, understood. Thank you, Mr. Means. I think that sounds good to give Mr. Farr 180 days to figure this out because it's in Mr. Farr, it's in your long-term interest to regain that access. However, if you can't in 180 days, we can revisit the options.
Well, the options, if you want to go ahead as soon as possible, I have no problem with the state doing the reclamation. I don't think that it would cost $11,000 or $12,000 to do it, but I think I could do it cheaper than that. But you know, the bund's already up. That's what it's up for. It's to make sure that it's done. And if you need that done as soon as you can, I don't think you're going to be able to do it before May anyway. And that would probably give me time to get legal access to get in to do it myself or to have a contractor do it to the satisfaction of the board. Now that's where I stand.
Okay. Board, any other questions for the division or Mr. Farr?
Well, I want you to be able to make a decision as to that I can live with or that you can live with.
I'm sorry, Mr. Farr. I'm just asking the board if they have any other questions for you or the division before we go into discussion.
Sorry.
Thank you. No, no worries. It's hard to hear. Any points of discussion within the board? Seems like there's two courses of action here.
Well, I guess, again, I would ask if Mr. Means would put what he said in a statement, you know, I'd make that motion. I like that, but I needed to reflect what you think was workable, and you said that, and so if somebody would put that on you know, in a form where I can make a motion, I'd be glad to do that.
I think we got that earlier. Patrick or Tim, do you have that in front of you?
I'm happy to take a shot here. I would move that the board find the permittee in violation of rule 5.1.2 parent D parent 6 for failure to maintain legal right of entry. Then we find the permittee in violation of rules 5.3.1 parent G, 3.1.3 parent 2, and CRS 34-32-116 parent 7 parent Q for failure to complete reclamation within 5 years of ceasing prospecting activities. That the board issue a cease and desist order prohibiting any further prospecting activities except those activities approved by the division in writing as necessary to comply with the conditions of the order, prevent damage to offsite areas or to protect public health and safety until corrective actions have been resolved to the satisfaction of the division. That those corrective actions within 180 days of the effective date of the board's order demonstrate the legal right to enter across the private land and obtain a new plan of operations from the U.S. Forest Service to complete the reclamation at the site. And within 180 days of the effective date of the board's order, complete reclamation of the affected land. I also move that the board assess a civil penalty in the amount of $200 per day of violation of the 56 days of violation for a total civil penalty of $11,200 with all but 1,000 suspended if the corrective actions cited above are completed to the satisfaction of the division within the required deadlines. And that the board may suspend all or portion, let's see, am I just repeating here? And that the board suspend all or portion of the civil penalty to encourage timely compliance with the corrective actions. Actually, I think that's within the purview of the board. Is there anything else I'm missing on the?
No, sir.
No, that's my motion.
Okay. Do I hear a second?
Second.
All in favor?
Aye.
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 Opposed, same sign. All right. Well, thank you again, Division and Mr. Farr. I wish you success, Mr. Farr, in gaining access. And we will hopefully have some good news in 180 days.
Well, let me ask one final question. Will I get some kind of a copy of what this decision is in the mail or by email?
Both. Yeah, you'll get it both ways.
Great. Okay. Thanks a lot.
All right. Have a happy holiday, sir.
You too. Bye.
All right. Now we move into the board action for file number M. Everyone good without a break?
Madam Chair, yeah, we're fine without a break. We have a little bit of a last minute twist and stuff on this item and stuff when wall staff is coming up here and getting set up. They'll present that to you, but I would like to reserve a couple of moments right before you close testimony and stuff and that to make a couple of comments. Yeah, John, we lost John for a second, so.
Okay. Okay. All right.
So it looks like we're taking a break.
Okay, so we'll take a break of what does Cammy think she needs? 5 minutes, 10 minutes?
It depends on how long it takes John to come back on.
Yeah.
So I would say 5 minutes.
Take 5, yes.
Okay, let's take 5. So we'll convene and reconvene at 11:03.
Why don't we do 11:05?
11:05. All right, thank you. Do we have connection now?
Yes, we do.
Perfect. We'll wait till Mr. Ortiz and Mr. Singletary put their videos back on. There's Patrick, thank you.
I will.
Looks like he's still trying to connect.
Cami, if you'd let us know when we are ready to begin. When everybody's on and.
There he is.
ready.
There he is. We got him.
Okay.
We're good.
All right. So again, well, everybody from that's involved with file number M210-7071, please swear to tell the truth.
Yes, I do.
Yes.
All right. Thank you very much. So Mr. Bowles, you have a presentation for us?
I do. Actually, before we get rolling on that, this is Jared Ebert with the Division of Reclamation, Mining and Safety. I just kind of wanted to tee this up and make the board aware of kind of a change or a request that we received late yesterday afternoon. So first off, the reason we're here for this hearing is for the consideration of a 112C amendment application submitted for the Goose Haven Reservoirs, file number M 2010-071, operated by the city of Lafayette. That application was submitted in response to a corrective action required by the board's order or by the board in an order for previous violation back in 2021. And so the amendment is for that corrective action. We've been reviewing that application over the last year, and there are still outstanding adequacy issues, and we have reached that maximum 365-day review period required under Rule 1.4.1.9. And there's still outstanding issues. Given that, we had informed the parties that we would be holding a hearing for the denial, approval with or without conditions of this application during this hearing on 3 different occasions back in October on the 26th, on the 10th and the 26th of October, and then again on November 18th. And then yesterday at 3 p.m., past 3 p.m., we received an email and a voicemail from the applicant's consultant requesting that this hearing be continued. So we informed them that they needed to make that request officially to the board today. And so with that, unless the board has any questions, I guess I'd turn it over to the city of Lafayette for their request.
Thank you. All right. Who is here from the city of Lafayette? Please identify yourself.
So my name is Melanie Asquith. I am the Water Resources Manager for the City of Lafayette. And with me today is Peter Wayland. He is the design engineer for the mining activities out there.
And just to confirm, you both raised your hands and swore to tell the truth today.
Yes.
Yes.
Thank you. Okay, please go ahead.
So my name is Peter Wayland. My company is Wheeland Inc. First, I have to say, I apologize to the board that you're seeing our faces again here. Unfortunately, we, on my behalf, did not adequately communicate to the city the need for us to create a witness list and and submit the documents required for me to present to you today. And so I'm asking respectfully if the board would consider the continuance of this action until the next available hearing. I feel like in that time that we can adequately address also the final adequacy review issues. I will say that since the adequacy letter of October 26th, a big ask on that was to present a groundwater model in support of hydrology issues. And a previous model was indeed developed for the site by CTL Thompson. I reached out to CTL in the middle of November to get those mod flow files, and the files, I got a response at the end of November indicating that those files couldn't be found. So I've been working pretty diligently to develop an entirely new model for this site, which is a fairly large area with some complex geology to the south of it. And that's the main reason, honestly, that we don't have the adequacy taken care of at this point. I think if we're allowed to go to the next hearing, that, we'll be in a much better position for you to make a good decision on this. Thank you very much.
Anything else from the city? Melanie? Ms. Asquith?
I can say that I am also very frustrated that the model was not complete. I had been given the impression that that everything was approved and we were good to continue working. But Mr. Wayland said that he has been working hard to get that groundwater model done, and we just asked for an extension so that he can get that submitted for the proper review.
All right, thank you. Division, do you want to continue with your presentation or just look for continuation?
Madam Chair, I have a couple of comments here and then we'll let the board decide what they would prefer to do. But on behalf of staff, I'd like to let the board know that staff is frustrated with the town of Lafayette and their consultants. The chronology kind of speaks for itself when you have 90 days past the filing date to correct a simple fee issue, along with delays and stuff and responses, and that it has pushed this application unnecessarily past 365 days. Asking for a continuance at 3 p.m. on the Tuesday before the board hearing is kind of disrespectful to staff and the board's time, and it is also disrespectful to our act and our rules. At this point, staff cannot approve the application that technically is a violation of the board order. If you grant the continuance, the board does not necessarily, or the staff does not necessarily disagree with that. But what we do ask is that the board set this for a hearing before the board in January. And with that, I will leave it up to the board.
Thank you.
I
Board
just,
question?
like to say that I'm very disappointed in the city of Lafayette. I mean, this isn't the first time, and I know the staff's been diligent, and it seems to me that we treat our other applicants and permittees in a certain way, and it seems like Lafayette feels like they're outside of those boundaries, and that really upsets me. And Mr. Means, I totally agree with you. But there's a sense of responsibility, and we have it, and you should have it as well. And if the board was so inclined, I don't know what choice we have other than to try and get it done, but it's pretty irritating, and I think you should be embarrassed about the way you're doing business in Lafayette.
I am embarrassed, and I take full responsibility for not managing my consultants like they should have been, and for double checking things that I was told. And I do apologize for that.
And I also take full responsibility for this. I'm sincerely apologize. I've been overextended in many ways, and that's not your fault, but I do apologize, and no disrespect is meant. Take this very seriously.
As Mr. Singletary pointed out, is our division works hard, and we understand that things, especially this day and age, everyone's strapped for resources. However, communication is the least that can be done, and that goes for we would expect nothing less than very good communications here on out. Board, any other discussion from the board members? Do I hear a motion for continuance?
Madam Chair, I've got a question for staff, perhaps. I mean, given that we're here, I guess I'm a little unclear of what waiting till January gets us. I mean, if we continue this versus just follow through with the staff recommendation to deny the AM2 permit application, is it 6 in one and half a dozen the other, or what's the advantages here?
By giving a continuance for 30 days, it does give them an opportunity to finish up the last items and stuff in that for the application. If the board denies the application today, then we go back to step 1, and because it's a board order, they'd have to start the entire application process over and start the clock. So an additional 30 days and stuff, well, not necessarily favorable and stuff, it does give us a cleaner path and stuff forward.
All right, then based on that, I reluctantly make the motion that the board continue this to its January hearing.
Second.
Okay. All in favor, say aye.
Aye.
Opposed, say aye. All right, so the city of Lafayette, please take this seriously, and let's hope the new year goes for correction of this kind of performance.
Yeah, it'd be a shame to start all over again, because it sounds like it's a compelling project. So hopefully you can get that in within a month.
Yeah, we'll have good communication with Brock within the next few weeks. Yeah.
Thank you. All right, last on our list today is a discussion item from the staff. Mr. Means, you're going to educate us today.
That's it.
I hope so. Pull it up. So what do we need to tell them? No, mine's on the driver. All right. That up. Okay, I'm sure.
We will zoom button. Yep, and then hit share.
There we go.
There you go. And then you can.
Got it.
Yep. Maybe not.
All right. Took me a couple seconds there and that. Thank you for your patience. Once again, this is Russ Means for the division. It's once again my pleasure and stuff to present to you the Jack Starner Reclamation Award winners for 2022. As some of the board will be aware of, in that Mr. Starner was an original board member who worked diligently to collect and disseminate information regarding successful reclamation and reclamation techniques. So we had 4 worthy submittals and stuff this year, and so I'm going to run through those 4 for you and present their work and that, so that the board can see some of the good work and stuff that our operators and stuff have done over the past year with reclamation. Our first award went to Wholesome for their work at the Slab Canyon Limestone Quarry. Wholesome worked on a technique that's known as island reclamation. They had limited topsoil. This is an older quarry up by Loveland. And so they took the resources that they had, and rather than spread them out thinly, they created these islands and stuff that created a juniper and pinyon ecosystem. What this did and stuff is it helped out with the obvious reclamation and stuff for the vegetation, but it also helped reduce erosion and also helped reduce the visual impacts and stuff from the project. And that, so with that, we thought that was an interesting technique that should be recognized. Our second award goes out to the Juan Pit for their wetlands work outside of Craig, Colorado. The Northwest Aggregates Juan Pit is located on the Yampa River just east of Craig. Through careful planning and mining, Northwest protected cottonwoods and wetlands along the Yampa corridor. By limiting impacts to the native established vegetation, reclamation recovery has been very quick and successful. Therefore, the division thought that it was worthy of noting and stuff that through careful planning and management, existing vegetation and stuff and that can be utilized and stuff to promote reclamation. Our third award goes to Albert Fry and Sons for the Wallstrom Quarry. If you'll remember, the Wallstrom Quarry and stuff had a contentious expansion and stuff here just in the last year and a half. Their work and stuff and that was primarily focused on bighorn sheep, a wildlife habitat and that. So what they have done is they've been able to show that mining and wildlife can not only coexist but thrive through the Fry Bighorn Sheep Initiative. The quarry activities are conducted with wildlife in mind and reclamation for future success. Through establishment of favorable slopes, creation of predator escape paths and shelter, bighorn sheep around the Wallstone Quarry have thrived. Along with these features that they've created and stuff here, they have also installed guzzlers. These guzzlers and stuff in that have helped the bighorn herd again gain an important foothold in the fragmented I-70 corridor. So congratulations to Albert Fry and Sons and the crew at Wallstone Quarry for their outstanding wildlife habitat success, in particular for the bighorn sheep. And our fourth and final reclamation award this year goes to Martin Marietta for the specification aggregates quarry for their outstanding concurrent reclamation. Actually, the specification aggregates quarry is one of our oldest quarries in our permit system. Through careful excavations and concurrent reclamation of the slopes and stuff, the Spec Ag for years has used the technique that is showcased from time to time. So today, we want to recognize those techniques and proven reclamation success. While excavation is in progress, the high walls are backfilled and graded, topsoiled and seeded. And here you can see the pictures and stuff above and stuff for the reclamation slopes up above it. And the work and stuff that they're doing is they're progressing down to the bottom of the pit. So with this work in that, the technique has proven highly successful in establishing a dense and diverse vegetation cover that attracts wildlife. And finally, just as importantly, this technique limits visual impacts to their neighbors in the community, whether standing from their near their entrance, across from their entrance, or driving west on I-70. Look back, and that will go on with that. You are challenged and stuff to identify that actual mining and stuff is occurring along the corridor. So for their ongoing efforts at the specification aggregates quarry, Martin Marietta and their crews are being recognized for outstanding concurrent reclamation. And as I noted and stuff at the presentation and at the Broadmoor, it's always nice and stuff to take the time and opportunity to point out the good things that our operators are doing and stuff, not necessarily being in front of the board and on enforcement issues. And with that, I am done. Are there any questions or comments and stuff that the board would like to make about the reclamation awards?
I would just commend the awardees. That's fantastic.
Yeah, I was going to say, Russ, it's great to see the transformation. You know, it's nice to be able to witness this kind of stuff. So thank you for bringing it to us.
Okay. All right.
Thanks for recognizing them. Yeah, that's great work to see the concurrent work going on as it's still an active mine. So
yeah. All right.
Thank you.
Madam Chair, with that, I'm done.
Thank you so much. Is there any public that would like to comment today? Cammie, is there anyone else on?
No, ma'am, there's nobody here for public comment.
All right, well, thank you very much. No need for executive session today. So happy holidays to all of you folks. Commend the division for a top-notch year and getting us well prepared for our board meetings.
Here. Happy holidays.
Happy holidays, everyone.
Holidays, everyone.
Thank
See you next year.
Bye now.
Yeah, I know, right? Okay.
You guys never looked at your room before?
No.